It's a Saturday night at your restaurant. Two guests at the bar have been there for a couple of hours, they've had a few rounds, and something sets them off. A shove turns into a swing, another guest steps in and ends up on the floor with a broken nose and a concussion. The police come, statements get taken, and 6 weeks later, the injured guest's attorney sends a demand letter. The letter names your restaurant for continuing to serve a patron who is visibly intoxicated. Your general liability carrier opens a file, and then a coverage letter comes back saying the claim is excluded. That's the moment a lot of owners realize for the first time that liquor liability is a separate policy from general liability, and that the coverage they thought was handling alcohol-related claims was never designed to touch them. If you don't know who I am, my name is Jim Eddington, and my agency helps individuals and businesses with their insurance every single day. Liquor liability insurance is coverage that responds when your business is named in a claim arising from the sale, service, or furnishing of alcohol. That includes the obvious situations: someone you served causes harm after they leave, and it includes a lot of situations that happen while the person is still on your property. The policy pays for the cost to defend the claim, and it pays for damages up to your policy limit if your business is found liable. Without it, those costs come out of the business. Liquor liability is usually not automatically included on a GL or BOP for a business that sells or serves alcohol. It typically has to be added specifically or written on a separate policy. And the list of businesses that need it is broader than a lot of owners realize. Restaurants, bars, breweries and wineries, caterers, grocery and convenience stores that sell beer and wine, wedding venues, country clubs, any business that added alcohol to its operations at some point and never had the coverage updated. Here's what the liquor exclusion inside a commercial general liability policy actually does. A standard general liability policy contains language that excludes coverage for bodily injury or property damage arising from the business causing or contributing to a person's intoxication, or furnishing alcohol to a minor or in violation of a statute. The exact wording varies by carrier and by form, but that is the substance of the exclusion, and some version of it shows up in the liability forms most restaurants and bars are written on. There is a carve-out inside that exclusion. If a business is not in the business of selling, serving, or furnishing alcohol, the exclusion does not apply to the incidental serving of alcohol at a business function. That is the host liquor carve-out, and we'll come back to it in the next chapter. If the business is in the business of alcohol, the full exclusion applies, and the GL policy is not going to respond to alcohol-related claims. To fill that gap, there are three common paths: a standalone liquor liability policy written by a carrier that specializes in this coverage with its own limits and its own forms, a liquor liability endorsement added to a business owner's policy, or a BOP, which bundles liquor liability with the property and GL on the same policy, or liquor liability added as a coverage on a larger commercial package for more complex operations. Which path makes sense depends on the size of the business, the carrier, and what the underwriter is willing to write. What matters is that somewhere on the schedule of your policies, liquor liability coverage actually appears with a real limit on the right form. If it's missing, or if it's on a form that doesn't match the exposure, the business is exposed. Here's a distinction that trips up a lot of people. There are two different scenarios where a business can end up connected to an alcohol claim, and they call for different coverage. The first is host liquor. An office throws a holiday party, a real estate brokerage opens champagne at a closing, a gym has a ribbon cutting with beer and wine. Alcohol is served, but the business is not in the business of selling it. In these situations, a standard unendorsed commercial general liability policy typically includes what people call host liquor coverage, which responds to claims arising from the incidental serving of alcohol at a company event. Endorsements can change that treatment, so it's still worth checking the policy rather than assuming. The second is liquor liability in the formal sense. The business is in the business of selling, serving, or furnishing alcohol for a charge. A restaurant, a bar, a liquor store, a brewery, tap room, a catering company with a liquor license. Host liquor coverage does not apply. The general liability exclusion kicks in, and liquor liability coverage is required. The line between the two is whether alcohol is part of your operations. If you sell it, serve it as part of a meal, or include it with a ticket or cover charge, you are not a host. You are a licensed operator and you need the real coverage. Dram shop is the legal framework that allows a third party, meaning someone who was injured by an intoxicated person, to sue the business that served that person. Every state handles this differently, and that matters for how liquor liability policies are written and priced. Utah has one of the broader dram shop frameworks in the country. Utah's Alcoholic Product Liability Act allows recovery against a licensee who serves alcohol to a person under 21, to someone apparently under the influence, to someone the licensee should have known was under the influence, or to a known interdicted person when that service leads to injury or death of a third party. The state's overall regulatory environment on alcohol is among the strictest in the country, and that shows up in how liquor operations are underwritten. Arizona also recognizes dram shop liability. Under Arizona statute, a licensee can be held liable for serving someone who was obviously intoxicated or a person under 21 when consumption of that alcohol is a proximate cause of injury, death, or property damage. Arizona case law has fleshed out what obviously intoxicated means, and it's understood as impairment a reasonable server would recognize from visible signs, not a formal test result. California takes a narrower approach than Arizona or Utah. Under California law, a licensee is generally not civilly liable for injuries caused by an adult patron's intoxication. The major statutory exception is furnishing alcohol to an obviously intoxicated minor, and that exception is taken seriously when the facts fit. Nevada is the most protective of licensees among these 4 states on the civil liability side. Nevada law generally does not hold a licensee civilly liable for injuries caused by an adult patron, even a visibly intoxicated one. The narrow exception involves knowingly serving a person under 21. It does not mean lawsuits never get filed, because defense costs are real even on a case the business ultimately wins, and it does not mean there is no exposure on the licensing or criminal side separate from civil liability. The takeaway is not that one state is safe and another is not. Regardless of which of these states you operate in, claims get filed, policies get tested, and the coverage you bought months or years ago is what determines how your business survives a serious claim. Here's something a lot of owners don't think about. Most people picture liquor liability as a drunk driving claim. A guest leaves the restaurant and causes a crash. A huge portion of liquor claims actually happen on your property while the intoxicated person is still there. Staircase falls are one. A guest who has been drinking for hours misjudges the top step going down to the restroom and ends up at the bottom with a concussion. On a sober guest, that may look like a straightforward premises claim. Once intoxication becomes part of the story, the liquor liability piece is likely to come into play, and that's often where coverage disputes start. Third-party injury without a fight is a quieter but common category. An intoxicated guest knocks a heavy item off a shelf onto another guest, causes a spill that leads to a slip, or stumbles into a server carrying a tray of glassware that ends up on a neighboring table. These claims don't look dramatic, and they settle for real money because the medical bills are real and the connection to overservice is not hard for a plaintiff's attorney to draw. Assault and battery is a category of its own. A patron is assaulted by another patron or by an employee, and alcohol is involved on one or both sides. Here's the part that matters. Some liquor liability policies include assault and battery coverage at the full policy limit. Some exclude it entirely. Some offer it with a sublimit that is much lower than the main policy limit. This is a specific coverage to ask about by name because the treatment varies sharply carrier to carrier. And 2 policies that look identical on the declarations page can be written very differently on this piece. One more thing worth understanding about how these claims develop. When a liquor liability claim gets filed, the carrier opens a file and starts paying defense costs from day one. Attorney fees, experts, depositions. Those costs can reach 6 figures before a case gets anywhere near trial. On some policies, defense costs come out of your policy limit, which means a $1 million policy that spends $200,000 on defense has $800,000 left for a settlement. On other policies, defense is paid in addition to the limit. This varies by form and carrier, and it changes how much coverage is actually available when the claim resolves. If your business sells or serves alcohol in any form, liquor liability is not a coverage you want to operate without, and it is not a coverage to default to the cheapest option on. That includes anything from a full-service restaurant down to a convenience store with a beer cooler, and any business that added alcohol to its operations at some point without revisiting the policy. A few things worth reviewing with your agent. The policy limit and whether it's high enough for the exposure your operation actually carries. The assault and battery coverage, whether it's included, excluded, or sublimited. How defense costs are treated on the policy, inside or outside the limit. And whether the policy responds to claims involving minors, employees, or off-premises incidents. At Western Pacific Insurance, we work with business owners daily, and alcohol exposure is one of the areas where the coverage details matter the most. We write business insurance in Nevada, Arizona, Utah, and California. If you serve or sell alcohol and you want a real look at how your liquor liability is written, get a quote at the link below or reach out directly to our agency. Subscribe to the channel. We publish most business days, and what we cover is for business owners and homeowners who want to understand their insurance before they need it, not after. Thanks for watching.